The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases will be submitted this afternoon. Those cases are Michael Jefferson versus Iowa District Court for Scott County. Second case is Ricky Rylea and Timothy Riley versus Iowa Department of Transportation. And the final case is State of Iowa versus Jeremy Werner. The last case is now submitted to the court without argument, and we'll hear the arguments in the Jefferson case. Mr. Hoover.
Good afternoon. May it please the court, counsel. My name is Stuart Hoover, and I appear today on behalf of Michael Jefferson. There are, in this case, I believe, 2 issues that are here to be addressed, and the first one is whether or not the District Court of Scott County erred in denying Mr. Jefferson's motion for correction of an illegal sentence when he was not afforded counsel, when he did not have the opportunity for an evidentiary hearing, and without so much as an explanation for the basis of the denial. The second issue deals with the subject matter of his motion, and that is namely whether or not a life sentence under, or a lifetime special sentencing under Iowa Code Section 903B.1 was grossly disproportionate to the crime which he committed, and in so doing, if it rose to the status of being cruel and unusual punishment. I, at least, find the record of Mr. Jefferson's case to be confusing. He started out by being sentenced in August of 2006. Then an appeal was filed. In October of 2007, he was brought back to be resentenced because in the original sentencing, he was never notified or sentenced to the special sentence under 903B. But he was brought back at the time that the appeal was pending. The Court of Appeals vacated the sentence, and so he was brought back a third time in November of 2008 to be sentenced again, and again received a 10-year sentence and the 903B special sentence. Early in 2012, he was released from prison, but then in 2014, he was found to have violated his parole and returned to prison, not because of any violation because of a sexual nature, but because of violation of terms of the 903B. Then in May of 2016, the defendant himself filed a motion to correct the illegal sentence, but he didn't do a particularly good job at it. He did, however, request oral argument and an evidentiary hearing. In May of 2016, the court denied that first motion without hearing and said that the court did not control when one was released from prison or under 903B sentencing. In August of 2016, the defendant filed a second motion, again asking to correct an illegal sentence, and this time he asked for counsel and reasserted the same issues. And on August of 23rd of 2016, the defendant filed to amend his first motion to include other issues, namely the issues raised here, particularly including whether or not it is a cruel and unusual punishment. The court denied his second motion, saying for all the same reasons that it denied the first. And then in September of 2016, the court denied the third, what it termed as the third motion, which was really and truly an amendment of the first motion. And again, it said for all of the same reasons. The problem is that this second motion and the amendment to the first had new issues, namely due process and cruel and unusual punishment. And in the court's denying it for, quote, all the same reasons, that would imply that the court didn't read it, that the court or overlooked it. Now, I grant you that they may not have been particularly well written, but he did do new issues and new points that needed to be addressed. At that time, he also asked for a writ of certiorari, which this court denied because this appeal was pending. Or perhaps it was the Court of Appeals, I apologize. But the issue comes down to his request for correction of a legal sentence and asking both for counsel and for an evidentiary hearing. We would submit that if the state raises it, that there are procedural issues which are at least questionable, but that this court has the ability to hear this at least based on a discretionary appeal or a discretionary review of an illegal sentence. The issues here are important, and the first issue is when does a defendant get counsel, and if he's entitled to an evidentiary hearing. And also, very significantly in this is the main issue which he has concerning the 903B
Excuse me,
special
Counselor.
sentencing.
Your client filed an application for appointment to counsel under Rule 2.28.
Yes, sir.
Did he file or make any argument that outside of Rule 2.28 he was entitled to counsel, say, a separate Iowa constitutional claim or other claim?
No, I don't believe he did, Your Honor, and I would submit that is part of the reason for counsel. I've spoken to Mr. Jefferson. He seems to be a man of reasonable intelligence. However, he is most certainly not an attorney, nor is he particularly well acquainted with this. So no, I don't believe he did, although perhaps he should have.
Is that issue before us then, whether or not the Iowa Constitution affords a right to counsel, or are we just dealing with Rule 2.28?
No, I believe that issue is before the court.
Tell me how.
It's before the court because we would contend that this is, by its nature, an illegal sentence, that it is a sentence which is intrinsic and critical to the underlying charge. I believe that the case law says that in order to be afforded a counsel, a case must be at, quote, a critical stage. And I don't know how an issue cannot be at a critical stage if it were not this one, because it involves a case where Mr. Jefferson is subjected to a lifetime worth of supervision by the Department of Corrections, which can involve imprisonment, which can involve all sorts of requirement and things impinging upon his life. So yes, I believe that the essential question of whether or not he's entitled to counsel is certainly part of this issue.
But as you cite in your brief, the Iowa Constitution is broader than the right to counsel under the federal Constitution because it has that separate phrase in all cases involving the life or liberty of an individual. So I'm just wondering how you raise that part of the Iowa Constitution when your client only raised 2.28.
Your Honor, I guess I would say that as part of the issues for this court, which is entitled to do discretionary reviews, that if one at the beginning does not have the sophistication to ask for the proper things, that this court can step beyond that and bring up the issues as they should have been formatted. I believe in particular there's a Iowa Rule of Criminal Procedure 2.281, if I'm remembering correctly, that indicates that the defendant is entitled to counsel at every stage of proceeding from initial appearance to probation revocation. And the court has also said that if one brings up an issue that is that should have been brought up in a different format, that the court can reform it to be into the correct format.
You know, we've also said, I think, that you can challenge an illegal sentence at any time, right, including on appeal, right?
Yes, sir.
So if, and I'm not agreeing with you necessarily that there is, but if there is a constitutional right to counsel associated with an illegal sentence and you can bring up the illegal sentence at any time, one would think maybe you could bring up the constitutional right at any time, including for the first time on appeal, right?
I would certainly agree with that proposition, Your Honor. The basis of this, and which sort of brings me to the second part of the argument, is that The Eighth Amendment of the U.S. Constitution and Article 1 and Section 17 of the Iowa Constitution talk about cruel and unusual punishment. And I believe the U.S. Supreme Court in Solemn versus Helm has stated that if there is a gross disproportionality, hopefully I'm saying that right, between the conduct of the defendant and the sentence, that it can give rise to an issue of being cruel and unusual or grossly disproportional. So the first question is, does this sentence lead to an implication of gross disproportionality? And we would submit that it does.
Well, it seems to me, if you are correct that you are entitled to counsel, isn't the proper resolution to remand rather than to get into the weeds of the merits of your claim? All we have, I mean, we don't have much below, of course. I mean, the record is almost non-existent. I mean, you filed your motion, and there was actually there were 3 motions, I guess, and amendments and
Yes,
so
sir.
forth and so on. But I mean, we're at the very initial stages. Isn't it premature to? I mean, you're asking us basically to grant you what amounts to summary judgment. It seems to me, and that's premature at this stage.
I hadn't thought of it in terms of summary judgment, so give me a moment to wrap my mind around that idea. But it would seem to me that if the issues are, if the main issue is whether or not 903B is appropriate and is constitutional as applied to this defendant.
Well, but the state, I guess my point is the state might have some evidence that they want to put in. I mean, and certainly some advocacy. They haven't had an opportunity to do that because this was dismissed from the get-go.
Well, I would certainly agree with that, because that puts us in a position which is precisely which Mr. Jefferson has put in, that he was not afforded the right to an evidentiary hearing, which he wanted to. He wanted to say that this is disproportionate. He wanted to make a record for this court so that it was not in the nature of judgment.
But you know, if I could, to use one of Justice Appel's terms, push back for a second. Under our cruel and unusual punishment jurisprudence, doesn't there have to be an initial threshold showing of gross disproportionality before there is a right to an evidentiary hearing? And Mr. Jefferson has an attorney now. You're the attorney, and can't we determine, based on what we've got before us already, if you pass that first threshold of gross disproportionality or not?
Your Honor, I believe that that's precisely the situation that we do face, that he was not afforded the opportunity to make that argument, nor frankly was the state, as to whether or not it was appropriate to do it. It seems that it's sort of a chicken and the egg scenario as to which came first.
What else would you need to develop in the record to, as far as the initial showing of gross disproportionality, which really, as I understand it, focuses to a large extent on general points about the crime and the punishment for the crime?
It does, but I think that you need to look at the particular factors of a given case. I think you need to look at the defendant's prior criminal history. I think it's important to look at, in fairness to the state, look at how this affected the victim and the victim's family, perhaps. The defendant's remorse, the need to incapacitate the defendant if that is necessary. And all of these things are the sorts of things that would have been brought up at an evidentiary hearing. And if this court directs that this case needs to go back for an evidentiary hearing, I certainly understand the reasons for that. But I also think that one can look beyond that and say that with respect to the charges that were brought against Mr. Jefferson, particularly that he was sentenced concerning a lesser included offense or an amended trial information under 709.4 for sex abuse in the 3rd degree, which is a statutory rape, that by its very nature should not draw the implications of this special sentence, which leave him on probation for life, whether or not that he at the age of 20-something is getting the same sentence that somebody who might have committed that crime at 60-something would be getting. So he'll be on for 60 years rather than 20 years, which seems inappropriate to me. That it would be a sentence which can send him back to jail for periods of time. It is a sentence which impacts his ability to live. It frankly, I don't know how to say this in a more eloquent way, but it's the registry itself sort of puts you onto a system where you're like being in the stocks in Salem, Massachusetts. That it's a public sort of thing where everybody's looking for you. Whereas if I commit some other crime, if I commit a murder, or if I commit terrorism, those sorts of crimes are. I see that my time is up. I just finished that sentence.
You may conclude and sum up.
All right. Thank you, Your Honor. We would submit that this special sentence is at least unconstitutional with respect to how it is applied to this statute and the matters which he was convicted of. Thank you.
Mr. Hoover, thank you as well. Ms. Hall.
May it please the court, counsel. First, briefly, I want to add to the timeline of Mr. Jefferson's probation. After his first revocation, he spent about 8 months in custody under work release status. And then in December 2014, he was again released on parole. 15 months passed before the state filed allegations that he had committed 4 additional violations of conditions of his parole. And the parole board revoked his parole again and returned him to prison in April 2016. Jefferson had counsel for both parole revocation hearings, and at least during the second one, he unsuccessfully made his argument that he considered his violations to be merely technical and not related to sex offenses. He did not appeal either decision. DOC records show that he was once again released on parole in early June of this year. And I also want to note that as to the length of special parole, Iowa Code Section 906.15 provides for the possibility of early release, and the Department of Corrections has fairly recently created a policy and procedure for seeking early release from lifetime supervision. That policy is set forth on the DOC website and became effective in November 2017. It sets forth.
So, but there's 2 issues here, as I see it, and maybe more. I mean, one is, was he entitled to counsel? And that's kind of a yes or no answer, I think. And then secondly, he seeks apparently relief on his claim, but in any event, we get into the cruel and unusual punishment issue. But on the first question of counsel, this is a motion to correct an illegal sentence before the criminal court. Isn't it part of the criminal proceeding? I mean, in common law, a motion to correct a sentence was available before the trial court. There's a number of cases from Maryland, I think the Third Circuit, and one out of Connecticut that say, well, a motion to correct a legal sentence is part of the underlying criminal proceeding. I use that term specifically, proceeding. And then as a result, is he not entitled to counsel under our rule and under the statute and under the Constitution?
The state's argument is no.
But why?
But
It's part of the criminal proceeding in the sense of it's on the criminal docket, and as you go back to trial court, it's not where you're held. It's not a PCR type claim. In fact, it's not actually a collateral attack at all. It's going back to the court to ask for a sentence to be corrected on the ground that the court didn't have the power to enter.
I think the terminology motion to correct a legal sentence is pretty broad, and have to look at the underlying claim, and is it really referring to an illegal sentence or
Well,
not?
but in Brugger,
In this case, he's challenging the special parole provision that the district court was required to sentence him under.
I agree with you that we should recast it. If you call it a rutabaga, but it's an orange, it doesn't become a rutabaga. He is challenging the power of the court on a cruel and unusual punishment claim. In Brugger, at least, we said that a claim of cruel and unusual punishment amounts to correction of an illegal sentence because the court, in theory, if you prevail, doesn't have the power to enter the sentence. So doesn't he have the right vehicle? I'm not saying he's going to prevail or not prevail right now. I mean, I'm just focusing in on the procedural vehicle. He's got the right vehicle, motion to correct a legal sentence on authority of Brugger, and he's got a right to counsel based on a criminal proceeding.
Well, as argued in the state's brief, we would disagree with that. Since 903B became effective in July of 2005, since that time, neither the Court of Appeals nor this court has found a statutory or constitutional right to counsel in connection with a motion to correct a legal sentence. And the Court of Appeals found the same way in...
If you found that a motion to correct illegal sentence had a right to counsel, then wouldn't also a motion for reconsideration of the sentence under 902.4 have to have a right to counsel as well, right? And that's usually, isn't that usually the defendant just writes from prison and tells the judge, I'd like you to reconsider my sentence?
If it was done in a timely fashion, but here we're a bunch of
Right, they're
years
two,
later.
that one's subject to a time frame,
Yes.
and this one has no time frame. But wouldn't you agree that the rationale would have to apply to both?
I think he's now under the supervision of the parole board, and if you look at 906.15, that is where we believe he needs to go to get relief. And now that they have this specific policy with steps to take to apply for early discharge, he can do that. And that policy says that the parole board decisions are final and no appeal is allowed, but the parolee may apply again in 1 year.
We've had cases up here where the state claimed that the sentence given by the district court was an illegal sentence because they didn't do a mandatory minimum, or they didn't, in any event, that the legal sentence was longer than the sentence given. And we've ruled that the state has a right to make that motion and entertain it. And is it the state's position, when you correct an illegal sentence, you're really resentencing anew, and in the situations where the defendant can get more time and a stiffer penalty, that defendant doesn't have a right to counsel?
In my experience, they typically do have counsel at resentencing hearings, especially if a certain amount of time has passed and it's relevant to present the person's prison disciplinary record and facts such as that might aid in.
I'm talking about a PCR, I'm talking about a resentencing in a proceeding where we held the original sentence was illegal. And if we find this to be cruel and unusual, I guess Brugger said it's a correction of an illegal sentence, he's gonna have to be resentenced. And isn't this just part of the sentencing procedure, which 228 will attach? I don't understand why it isn't. And you say because we said in our brief, but explain it to me.
Well, there's been several Court of Appeals opinions in there. They've consistently found no right to counsel, but they've been rather inconsistent as to whether or not the person making the motion for illegal sentence.
What's their rationale supporting it? I mean, I didn't follow it. And they're unpublished anyway, so they have no presidential value.
They just analyzed looking at section 815.10 subsection 1 and rule of criminal procedure 2.28. The language.
I think this is an important point about if the state files a motion with the district court to, and says, you know, like has happened in this case, and says, hey, by the way, we forgot something, you need to add something to the sentence, and let's say the procedendo's issued, the case is otherwise final, does the defendant have a right to counsel to oppose the motion, or does the defendant not get counsel unless and until there's actually a resentencing order?
In most of those cases, I would say the defendant has no argument to oppose what the district court was
It's really
statutory
factual. I really don't know. I mean, is there a process by which the defendant is afforded counsel in those cases or not? If, just on the basis of the state having filed a motion saying, Judge, you made a mistake, we need to fix the sentence and add this in.
In Mr. Jefferson's case, I'm not sure exactly what point or who decided that, oops, we didn't put the 903B.1 on there. So that was part of one of his resentencing. And he has, in his direct appeal and PCR, made arguments against applying that to his sentence.
There's a body, oh, go ahead.
I was just wondering, following up on Justice Wiggins' question to your opposing counsel, if he didn't raise the Iowa Constitution in his motion for counsel, just relied on Section 2.28, should we be reaching the Iowa constitutional issue?
In connection with the right to counsel? Because he did in his motion to amend, which was his third motion that basically crisscrossed in the mail with the court's ruling, he did throw in Iowa Constitution as a basis for his illegal
Okay, and
sentence.
the Court of Appeals addressed that issue. It reached that issue, held that he didn't have that right. So is the state today arguing he failed to preserve it, or is that is that fair game for us to decide?
We, of course, would argue it was not preserved. And I think the Court of Appeals, the Court of Appeals found he'd waived error in terms of not asking the district court to provide additional reasons for the summary denial of his motions.
Would the state, if we sent this back down, would the state want to develop a record on the right to counsel issue?
It's possible, but I really don't know what else we could provide other than, you know, the statutory and criminal rules that already exist.
Does he have a statutory right to counsel to challenge his sentence on sort of the Brugger grounds?
No.
That's assuming this isn't a criminal proceeding, right? Because
Correct.
Well, wait a minute. I'm reading the rule differently, maybe. It says, at every stage of the proceedings from the initial appearance before the magistrate or the court through appeal. Am I? Okay, is there something else I'm misreading?
It also includes PCR and probation revocations.
But does through appeal mean you got to get it, you have a right to counsel until your first appeal, but the statute?
Not after which level are we talking about?
Not after your direct appeal, but under the statute, why doesn't he have a right to, a statutory right to counsel now? Because he's already exhausted his direct appeals, or is there another reason?
I think we're relying on the wording of the statute, and all the numerous cases that have interpreted up to this point have not found a statutory right to counsel in connection with a motion to correct a legal sentence. And in this case, we're even more attenuated because we're on the parole side of it. It's long after he's discharged his criminal sentence, exhausted his direct appeal, PCR appeal, did not appeal his probation revocations through the process that he could have. If
Excuse me for a second, was the district court wrong, was the Court of Appeals wrong when it said the state does not contest air preservation either as to right to counsel or the illegality of a sentence? Because you say you're saying it wasn't preserved, and they said, the Court of Appeals found you didn't contest the preservation issue.
In the district court? We didn't file anything.
No, the Court of Appeals said that the constitutional issue was preserved and you didn't contest it, and now you're telling us today you're contesting it.
I think what the Court of Appeals was focused on waiver-wise was just the, not asking the district court to provide additional reasons to support its denial of his motion. We were thinking that if the question before the court is when is an evidentiary hearing warranted on these types of motions, and what is the standard that a parolee or convicted sex offender must meet. The state believes the district courts should be the gatekeepers and allowed to exercise discretion in evaluating whether a person challenging his or her extended parole asserts a colorable claim of gross disproportionality.
The court didn't rule on that, it doesn't seem. I mean, I hear the argument, but it looks like the court, in the first instance, in response to the first filing, basically said, well, your parole status is not up to me, it's up to the parole board. End of story. Fair enough.
I agree that the second and third motions.
Second and third, then it
Throughout
elaborates, but we get the same order back.
Correct.
And without disparaging anybody, it looks to me like the district court just put out the same order and didn't consider the new arguments. And so shouldn't we send it back to the district court if that's the case, to let the district court cogitate on these matters?
It does look that way, but the state would argue that there's enough of a record for this court to decide the merits of the cruel and unusual punishment challenge. I see my time is up. The state would ask the court to affirm the district court's denial. Thank you.
Thank you as well, Ms. Hall. Mr. Hoover, rebuttal?
The state makes a number of interesting arguments. The one I find, the first one I found that I would like to address was the provision about the early release. Yes, there is a provision for early release, but I don't think that that means that the sentence cannot be cruel and unusual. I don't think that that means it cannot be disproportionate. So if for no other reason that the fellow will have to go through the process where we would submit that it shouldn't be part of the sentence at all. I would also submit that this is a case with the nature of 903B sentencings, that at any point in this, your sentence can get worse for things which are simply not illegal activities. Your sentence can get worse because you're living with your own children. The sentence can get worse because you're associating with somebody else's children, which is simply not illegal in and of itself. And so I don't see that the provision that you could get out of something which is otherwise illegal somehow makes it legal. And I don't think that it is appropriate to say that.
And I take your argument, and I take it seriously, but isn't it sort of a combination of several things? I mean, it's not so much the lifetime parole per se, it's the lifetime parole with various other conditions. For example, the sex offender registration requirements, which we have determined are not a form of punishment. Isn't that what you're really objecting to? It's not so much this lifetime parole.
Well, if you were asking me, I would be objecting to all of it. But
that is what I'm asking, and I think that's what I understood your position to be.
I'm going beyond what the issues are here today, but I think that you can make a very decent argument that the whole concept of the registry is disproportionate. That it provides for these varying punishments including this, putting yourself out before the world and your past out before the world in a way that is beyond the sentence that you have. If I
But
commit,
isn't this about not so much your client, the legislative history, and according to State versus Wade, the purpose of the lifetime is to protect other people. This isn't just about your client.
that is so, but it is also, I would believe my contention, or it would be my contention that it doesn't do that. It may be intended to do that, but it doesn't do it at all. I think that the registry.
How do you prove something that didn't happen?
Well, that's very difficult to say. To say that someone wouldn't have been a recidivist if he hadn't been required to be on this registry. These are the impossible questions that's hard to answer. But it would seem to me, just frankly from my observation of it, that the registry itself doesn't do anything other than make situations worse and more harmful for the public at large. Although I really am kind of going beyond what the issues here are today, and I apologize for that.
The 2 revocations that he did not challenge, your client may minimize what those rules were that he violated, but regardless, by him not challenging those, would you not agree with me that he did violate some terms, some basic terms of what the corrections had decided he should do?
He did, but he didn't violate terms that would endanger the public for the activities that he engaged in at the beginning. There's certainly nothing wrong with the state of Iowa or the state of Hawaii or wherever saying that we're not going to put up with this kind of behavior. There's nothing wrong with that. But the things that he violated were not that behavior. It was not directed at it, nor did it protect the public, I think, in one little bit from the activities that he was punished for in the first place, which is the purpose, I believe, of incarcerating anybody, the purpose of suspended sentence, the purpose of a fine, the purpose of any of the criminal statutes. And this statute, this registry, and the lifetime parole that is our specific focus here today, frankly, I think just doesn't protect anyone. And I see I'm out of time again.
Thank you, Mr. Hoover.
Thank you.
The case of Jefferson versus the Iowa District Court is submitted.